And this is one of those instances where the law just doesn't make sense. You can be sentenced to a minimum of 3.5 years for possessing a loaded weapon, but only 2 years for menacing a police officer with a weapon that you possess, which makes no sense to me. But be that as it may, again, my job is to find what the appropriate sentence is for somebody who's now accepted responsibility and was intoxicated at the time of this incident. But the bottom line is, no police officer should have a gun pointed at them during the course of their duty, during the course of their life. And if you point a gun at a police officer, and that's what I think happened, based on all the evidence I've seen, if you point a gun at a police officer, there are going to be consequences. And in this case, the consequences are that the sentence is going to be more severe than if you had just possessed the weapon. And it just clearly, I don't know why everybody's talking about whether he had fired or not fired. If the officers reasonably believed that he had fired or they were under fire, I don't know that they fabricated that fact. But if the defendant had fired or attempted to fire his gun, this clearly would be a different case, and this sentence would be much more harsh. But I think a harsh sentence is what's necessary. So accordingly, with regard to the menacing of a police officer, the Class D violent felony of the Penal Law Section 120.18, Mr. Allen, your sentence is 58 months, a determinate sentence of 58 months of state prison, followed by 2.5 years of post-release supervision. There's a $300 mandatory surcharge, a $25 crime victims assistance fee, a $50 DNA fee. I'll direct that be taken from inmate funds. With regard to the conviction for criminal possession of a weapon in the 3rd degree, the C violent felony offense, your sentence is 58 months and 2.5 years of post-release supervision. The 58 months will run concurrent to the menacing of the police officer charge under the first count that I sent you on.